This is Agriculture Today. We are back now with Roger McEowen. He is our K-State and Washburn University School of Law Ag Law professor. So, Roger, thanks for joining us.
Good to be with you, Samantha.
Absolutely. So today we're going to be talking about depreciation. It's not a subject I'm very knowledgeable about, but that's why you're here, right?
Well, I hope so.
Yes, you are extremely knowledgeable about it. And from what I understand, there was a question surrounding a case where they were asking, when can an asset that is being used for farming business purposes begin to be depreciated? So let's kind of start with, what does it mean to take out a depreciation deduction?
Well, depreciation in theory and in its application is a tax allowance for the exhaustion or wearing out of an asset that's used in a taxpayer's trade or business. So we see it used heavily by farmers and ranchers. In fact, the depreciation schedule for a farmer and rancher takes up probably the largest portion of many of them for their tax return. Page after page after page of schedules of depreciation for many farm assets, from tractors and combines to trucks, any type of equipment, other tangible property that's used in the business that has an exhaustion factor and has a useful life of more than a year and is not real estate is generally going to be depreciable under one of various methods.
Good to know. And from what I understand, when it came to this farming equipment that this case that we'll talk about here in a moment, they were trying to take out a depreciation deduction on a piece of equipment, but it wasn't considered placed in service yet. So what does that exactly mean?
Well, this is a big issue, and we get into this time of the year, and typically what I start seeing are advertisements from various ag retailers and farm magazines that are saying, well, basically, if you sign a contract with us by the end of the year, you can start to claim depreciation on the asset that you purchased by virtue of that contract. And it leads them to believe that that is regardless of whether they've actually taken delivery of it or whether it's at the farm or whether it's ready to be used, whether it's still at the dealer or not. And that's not the case. We have to meet a placed in service rule, and that's the measuring rule that IRS uses to determine the first tax year in which an asset that's used in the trade or business of farming is eligible to be depreciated, and when you can start that depreciation. And what that basically means is that the asset is ready and available for use in your trade or business. And just simply signing a contract does not mean that the asset that you purchased, even though you paid for it, is necessarily ready and available for use, or could be used in your business if you wanted to. So if I sign a contract to build a building, to have a building built on my farm that I'm going to use in my farm business, then I need to have more than just simply a pile of lumber dropped in my barnyard by December 31st. I need to have that structure up and ready for me to use it as of December 31. Whether I actually put it in use or not is not the point. The point is it's ready and available for me to use as of the end of the year if I wanted to. Same thing for buying a tractor, buying a combine. Has it been assembled? Has it been delivered to the dealer? Is it serviced? Is it ready to go? It would meet the definition of placed in service. Now, if it's ready to go, but it's at a dealer 1,000 miles from my farm, that's a different issue. But if it's ready and available to use, and it's ready at the dealer and I could pick it up, take it to my farm and start using it by December 31, that's enough. I don't actually have to use it. It's just ready and available for use as of the end of the tax year. But these ads that indicate that all you have to do is sign a contract, that's not enough. And IRS is not going to agree with that at all.
Sure, yeah. And I mean, the IRS has the final say in this matter, not whoever you're buying this equipment from. So making sure you understand those guidelines is definitely important.
That's right.
And I mentioned a case earlier that we were going to talk through, and it's the Stein case. And tell us a little bit about this. I know this was several years back, but important implications.
Yeah, this is a federal case decided by the federal court in Louisiana in 2015. The IRS did not agree with it. They filed what's called a non-acquiescence in the spring of 2017. But this is a taxpayer that had a retail business that sold home building materials and supplies. And they built 2 new retail stores, and as of the end of the particular tax year, the buildings were substantially complete, partially occupied, and the taxpayer had obtained certificates of completion and occupancy, and customers could enter the stores, but the stores were not open for business as of the end of the tax year. Well, the taxpayer claimed a depreciation allowance for that tax year on the 2 buildings, which created a tax loss on the return. They carried those losses back to prior years, which you can do under the loss carryback rules, and they got a refund. IRS came in, disallowed the depreciation deduction, of course, changes the refund to a tax liability. And the IRS said, well, you hadn't placed the buildings in service, and the deficiency the IRS assessed was over $2 million for the tax years in issue. So it was a big deal. Taxpayer pays the deficiency, sues for a refund. They get into federal court, and the IRS said, well, you have to match up the expense with the income. And since you didn't have any revenue from the income in that year, you can't take the expense. But that's not the test. And the federal court told the IRS that's not the test and ruled against them, granting summary judgment for the taxpayer and saying that building is ready to go. It doesn't mean that they actually had to have sales or actually used it. It meets what's known as the placed in service definition. And so that's a key point. And the IRS apparently didn't learn their lesson because they issued a non-acquiescence to the case, but they can fight that all they want. The case law is pretty solid on that point.
Absolutely. Yeah. Another reminder of knowing the details of these sort of rules and what they actually mean. And going forward from this case, what are some major takeaways in your opinion, Roger?
Well, as I said earlier, I think farmers need to be on the lookout for end-of-year promotional ads in farm magazines stating that a contract could be signed or delivery taken before year-end, which would allow them to have a depreciation deduction for that year. That's not correct. And you've got to do more than just merely sign a contract. That asset, as I said earlier, has to be ready and available for use in your farming business. So I think the big take-home is don't get lured into a bad tax result by inaccurate sales information. Remember, these companies are there to sell their product, and that's fine. And they're pushing hard in a down economy to keep their sales up. They're not in the business of providing sound tax advice. So take those ads that you might see in a farm magazine, take them to your tax practitioner, your CPA, your farm CPA, your farm tax attorney, and have them look at it for you before you sign something on the dotted line.
Understanding terms and agreement sort of things is one thing, but understanding the tax implications is a whole other. So good reminders for sure. And Roger, I know you recently wrote an article up about this subject specifically, and you write tons of articles every single week in regards to, latest updates when it comes to ag law subjects. So tell us a bit about where listeners can find that at.
So this is on my blog that can be accessed through my website, which is washburnlaw.edu/WALTR. It's also on the Ag Manager website, and this is a blog article dated October 28th of this year, so just a few days ago.
We will link to this article specifically in the show notes of today's program, which can be found on agtoday.net. But Roger, as always, thank you so much for your time and for your insight.
Thank you, Samantha.
Once again, that was K-State and Washburn University School of Law professor Roger McEowen for this week's Ag Law Update.